Okay, I've been trying to explain to a lot of people, but they don't believe me. If you've been denied a quick and speedy trial, well, let's just say you go what the law says. Laws on the internet. Yes, there are a lot of things you can believe on the internet. Yes, a criminal case can be dismissed for denying defendant's right to a speedy trial. The Sixth Amendment of the U.S. Constitution guarantees that right, and if prosecution fails to bring the case to trial within a reasonable time frame, the charges may be dismissed. Here is a more detailed explanation. Right to a speedy trial. The Sixth Amendment protects individuals' right from being held in custody or facing charges for a reasonable period of time without a trial. Dismissal as remedy. The court determines the defendant's right to a speedy trial has been violated. The appropriate remedy is often dismissal of charges. This means the case is closed and the defendant is no longer subject to prosecution. Factors considered. Courts consider several factors when determining when a speedy trial violation is incurred, including the length of delay, the reasons for the delay, defendant's assertion of the right. And if you do not ask for it or demand it, you will not get it. Nobody's going to bring it up, people. Nobody's going to bring it up. The defendant's assertion of their right, and any prejudice to the defense. Okay, Speedy Trial Act. Like I said, nobody's going to bring up your right to a speedy trial, and you're not going to get it if you don't ask for it, demand it. I've helped a lot of people. People that got out on bond, I would automatically tell them, demand a probable cause hearing. The judges don't like that, And there's only one judge I've seen that's done that, and that's in Texas. I'm in the state of Illinois. But I've stopped a lot of people from going any further than a probable cause hearing, which makes it over quick, fast, in a hurry, the same day, the first day they go to court. Because if they don't, they said, I always tell them, if they don't grant you probable cause hearing, ask for a quick and speedy trial, demand effective assistance of counsel, go over the rules of professional conduct and the code of judicial conduct with the judges and the lawyers to see that everything is played out by the book. So that way you receive a quick and speedy trial. You receive effective assistance of counsel, in which will determine whether or not you had a fair trial. And this is due process. Failure to do anything I mentioned is a failure at due process. State laws may also have their own provisions regarding speedy trials, and the dismissal charges may be remedy for violations of those laws. The right to a speedy trial in a criminal case law. Okay, there's a lot of people that talk about it. Bar Association, Office State Appellate Defender.gov. And I can't count how many times I had to argue with the public defender. They'd have people come in here, sign this, and you can leave. And I'd have to warn people, you're leaving with a felony. That's ineffective assistance of counsel. He's not abiding by the rules of professional conduct in any fashion or form. He's supposed to defend you as if he's defending his own life, liberty, and pursuit of happiness. Telling you to sign that and leave here with a felony is beyond ineffective assistance of counsel. That's destructive and defective assistance of counsel. And the state's attorney's not stopping them. The state's attorney is required to report misconduct. That's misconduct. Failure to report misconduct is misconduct. The state's attorney is legally required to report any misconduct, whether it be in the rules of professional conduct and the code of judicial conduct. The judge was responsible for citing your attorney for ineffective assistance to counsel. Thus, them working together is a conspiracy to deprive rights under the color of law. Okay, let's go here. Quick and speedy trial means a trial must be held within a reasonable time frame. Usually, specifics generally requires a trial begins 70 days of arraignment if the defendant enters a not guilty plea. Some states have their own time frame. Here's a more detailed time frame, Federal Speedy Trial Act information. Okay, I'm just telling you what a quick and speedy trial is, and if you didn't get it, that's a get out of jail free card. The Menendez brothers could get out on that, depending on how many violations there were in the rules and the codes. But, I mean, you're not going to get effective assistance of counsel if you don't study the rules of professional conduct and the code of judicial conduct. You're not going to get a fair trial. You're not going to get effective assistance of counsel. If your lawyer hasn't mentioned their legal obligations to you, the court's legal obligations to you through the rules and the codes, you're not dealing with effective assistance of counsel. Okay, state laws, misdemeanors, trials may need to be held within 45 days of arraignment in some states. Felony trials need to be held within 60 days of arraignment in some states. States variation timeframes can vary significantly by state. It's important to consult specific laws of jurisdiction in question. So whatever state you're in, that's what you're going to want to look up, what their time frame is for a quick and speedy trial. And it's rare that anybody abides by that, you know. So that's part of the due process thing, you know. And anybody accused of a crime, no matter where they're from, is entitled to due process. It doesn't say except. No, anybody accused of a crime in any state, whether it be state, local, you know, or federal, has a right to due process. Assertion of rights. A defendant's assertion of their right to a speedy trial is a factor considering determining whether a violation has occurred. Reasonable time frame. The Sixth Amendment right to a speedy trial is often interpreted as a right to a trial within a reasonable time frame. Consequences of violation. Dismissal of charges. If a speedy trial time frame is violated, charges against the defendant may be dismissed according to some legal sources. Okay. What is the time limit for a speedy trial? For infractions and misdemeanors, a trial must be held within 30 to 45 days of arraignment. For felonies, a trial must be held within 60 days of arraignment. Okay, people are looking for the easy route. But remember, if you've been denied quick and speedy trial, you were denied effective assistance of counsel, you know, so you can also cite your attorney for ineffective assistance of counsel, the prosecutor for prosecutorial misconduct, and the judge for judicial misconduct, because it's everybody's legal obligation in that court of law to see to it that you had a speedy trial. But they won't. If you don't demand it, you don't ask for it, they're going to say, hey, you never brought it up. And I don't know if there's anybody out there that remembers me. I haven't been to court in a while because, well, the handicap thing. You know, I can't get around and hurts to walk. And but either way, what is the longest you can wait for a trial? Trial must commence within 70 days from the date the information or indictment was filed, or from the date the defendant appears before an officer of the court which the charge is pending, which is later. People don't believe me. And I actually used to have this printed out, you know, copy it off of books, you know, before you could, I didn't have the internet back then. What is a fast and speedy trial? Okay. There's a lot you can learn from the internet. I'm just pointing out the things I read to you about. And that's what's made it so important for me to get a computer, figure out how to use it, program it, maneuver through the internet, find out how to use the internet. I always heard people to say, you want to find out things, ask the internet. And I wanted on all these different sites, and nobody could tell me where I could find what I needed to find. And when I started asking the search engine, it made it real easy. I mean, I knew this stuff, but I just wanted to find the law and point it out. Okay. So there's a lot of people talking about this, just nobody enforcing that law. Why? Because you aren't demanding it. You aren't asking for it. It's crazy. How can it be a right? It's supposed to be happening, but it won't unless you bring it up. And a quick and speedy trial usually starts with a probable cause hearing to see if there's probable cause to proceed, which in most cases there aren't. They spend an awful lot of time trying to convince people just to sign off on the gift, what they're offering in the first place. If you don't take that, they're going to make life really hard on you. And the more times they offer the gift, the more you refuse, the greater the consequences you'll face, unless you learn the law. Like I said, the easiest way is to make sure you go in there and take a copy of the law for the quick and speedy trial. Take a copy of the rules and the codes with you. Take a copy of the law for the letter of the law, so make sure everybody does that word for word to the letter as prescribed in the letter of the law. Don't forget the rule of law. That's quite easy. Everybody's equal under the eyes of the law. Okay, so I'm going to make this one short. But as you can see, okay, so I told you, it must be within a certain time frame. And if it's not, then what happens? A criminal case can be dismissed for denying offendants' right to a speedy trial. Yeah, that's pretty simple, if you ask me. A lot of people used to get mad at me, especially lawyers and judges. How do you know? Are you a lawyer? I can read. I learned to read before I started school. Got a lot of hate for that, too. But, I always felt when somebody said, things are on a need to know basis and you don't need to know, I always felt the need to know. It's like when people say having a gun is better to have one and not need it and need it and not have one. Well, the same thing goes with the law. It's better to know and not need it and to need it and not know it. Okay, and I'm telling you, things aren't gonna happen. You're not gonna have due process if you didn't have a fair trial. You're not gonna have a fair trial if you don't have effective assistance of counsel, which is described in the rules of professional conduct in the Code of Judicial Conduct. Okay, those are the legal obligations of all lawyers and judges. Without effective assistance of counsel, you won't have a fair trial. Okay, just trying to get you open your eyes and know what you need to know. I said I don't post opinion, I post fact. And like respect, knowledge isn't a given, it's earned. And the only way you're going to earn your way to your constitutional rights, you're going to earn your rights to the Bill of Rights. As a citizen, your birthrights, if you don't know them and own them, they'll never exist. Okay, so remember when you've been denied your quick and speedy trial, don't forget to cite your attorney for ineffective assistance of counsel, prosecutor for prosecutorial misconduct, and the judge for judicial misconduct, and you'll be out quick, fast, in a hurry. Because that's clearly a conspiracy to deprive rights, or now they call it conspiracy against rights under the color of law. Okay, they conspire to deprive you your right to a quick and speedy trial. I mean, that's nobody bringing it up, nobody offering it, not happening is a violation of your constitutional rights. Okay, remember who you are. One of many who I dedicated a lifetime to, going on 50 years. One of many of we the people, millions and the millions of you. I've been pushing hard, nearly lost my life. I had to stop what I was doing for me, but it didn't stop me what I was doing for we. When it comes to we the people, y'all my people. All y'all. Young, old. Mr., Mrs., Ms. I don't care what you refer yourself to, if you use a pronoun. If you're a member of the LGBT community, which I'm not, but you're still a citizen of the United States. And I would not deny or dare to deny you your constitutional rights, because I would be breaking the law. I would literally be breaking the law. The law of public service, it's known as the oath of public service. Violating the oath is punishable. Fines, removal from public service, and incarceration. And depending on the degree of the effect, it could mean death. I'm not. I've always been against the death penalty, but it is the law, though. If a person's life was taken under the color of law through the deprivation of rights, the law would be required, as some people would say, an eye for an eye. It's required. All right, people, nothing but love for you. All right, peace be with you. And may the law serve you well as it served me. Knowing what I know has kept me out of harm's way for a long period of time, and it's helped me help others. Somebody stole my identification, and I had a litigation team come after me, wanting money, threatening to take me to court, And I spoke with them about the law, and they started throwing them at me, and I started throwing what I knew at them. They apologized, capitulated, and eliminated that debt. Okay, so I'm just saying, I'm not bragging, I'm just saying, if I can know this, so can you. I had some people say I was pretty smart, but they learned what I learned and laughed at me when I called them a genius when they used it. I wasn't bragging on myself. I was just happy that I kept them out of the meat grinder, what we know is the judicial system. Okay, I gotta go. I want to keep this short so I don't lose your attention. But this is pretty easy to use the law if you just read it. Okay? Nothing but peace and love. I wish you nothing less than a long life and good health.